The council will be dealing with issue number one. Before the council proceeds with the argument, I would like to ask the bench if is well versed with the facts of the case.
Yeah.
Much obliged. Your Lordship, the first issue before this honourable bench is whether the division bench of the High Court of Champaner was correct to dismiss Raja Retreat's claim for specific. The council will be dealing with this issue in a fourfold manner. Firstly, the council will be establishing how that the instant case does not satisfy the test of being a materially adverse effect in order for the respondents to claim termination of the contract. Secondly, the council will be establishing how this falls within the tenets of section 10 of the Specific Relief Act, which says that the contract is specifically enforceable, however subject to section 14 of the Specific Relief Act. The third fold of my submission will be that the conduct of the Summerfest, known as Chaos in Champaner, while being a significant factor of our revenue stream, but was not the only revenue stream. And finally, the council will be contending that the petitioner has always acted in good faith and has also been ready and willing to perform the terms of the contract, especially because this is a suit for specific performance. Now, Your Lordship, if I may move with the first fold of my argument. I am obliged.
Which will be your first argument?
Lordship, my first argument is that the test of material adverse effect has not been satisfied or fulfilled in the instant case.
All right.
Yes, Lordship. If I may proceed.
Yes, yes.
Much obliged. Lordship, the attention of the bench is drawn to para 3 of the facts of the case, more specifically the definition clause, which basically defines what the material adverse effect is. It states that any event or circumstance which would reasonably be expected to materially and adversely impact the assets, liabilities, business operations, performance or prospects of Raja Retreats Limited as a result of changes to economic, political or market conditions, but not changes in laws, rules, regulations, orders or other governmental actions as applicable to Raja Limited or the industry. Now it is the humble submission of the council that in the instant case, COVID-19 as a pandemic and the subsequent lockdown which was imposed was clearly a governmental action and hence falls under the head clause 2, subclause 2, which is other governmental action. Now the council would go a step further to establish that there is a proviso to this clause, that provided that the changes, the very next page, Your Lordship, provided that the changes noted in the exclusion specified in para 2, subclause 2 above may be considered a material adverse effect to the extent that they have a disproportionate effect on Raja Retreats Limited in comparison to other companies in the very same industry. Now, it is the humble submission of the council that COVID-19 as a pandemic, which was unforeseen and unprecedented, had an impact and ramification on the entire industry as a whole. Therefore, there does not arise a circumstance where Raja Retreats Limited has been disproportionately affected when compared to other concerns in the very same industry.
But you are the plaintiff, right? You are Raja Reddy.
Indeed, indeed.
You are representing Raja Reddy.
Indeed.
So, just tell us how the material adverse effect will have a bearing on your suit for specific performance, because it's not affected you.
Indeed, Lordship.
Material adverse effect is only on
an argument.
Indeed. However, the reason why the council is defending that it does not fall within the parameters of material adverse effect is because that was invoked by the respondents to basically terminate the contract. Therefore, I must establish and prove before this bench that it did not constitute a material adverse effect for the respondents to even terminate the contract in the very first place. Much obliged. And I am thankful for that question, Your Lordship. Now, Your Lordship, as I have already established that the material adverse effect clause has not been satisfied, therefore, there arises no ground for termination. And Your Lordship, as already reiterated before, that the lockdown imposed and COVID-19 was something unforeseen and unprecedented, which was not within the control of the petitioners. Now I'll be moving to the next fold of my argument, which is to state that section 10 of the Specific Relief Act is satisfied in the instant case, and I would like the attention of the bench, if they may, to section 10 of the Specific Relief Act. Lordship?
Yes.
Section 10, if I may read. Specific performance in respect of contracts. The specific performance of a contract shall be enforced by the court subject to the provisions contained in subsection 2 of section 11, section 14 and section 16. Therefore, this needs to be read along with section 14, Your Lordship, which brings me to section 14. Contracts not specifically enforceable. Contracts not specifically enforceable. The following contracts cannot be specifically enforced, namely, subclause A, where a party to the contract has obtained substituted performance of contract in accordance with the provisions of section 20. So, Your Lordship, the corollary to this is, if the party to the contract has not obtained the substituted performance of the contract, then it means that the specific performance can be enforced. In this instant case, it is the humble submission of the council that the substitute that the council is referring to is the very fest, that is the Chaos in Champaner Fest, which is usually hosted in summer. But there were potential talks for a winter edition of the fest. Therefore, that even if the councils for the respondents contend that the fest itself and the cancellation of it is a materially adverse effect, we were making everything which was within our frame to provide for an alternative arrangement. Now, but I will be focusing more on...
What is the substantial question of law you are arguing?
Lordship, the substantial question of law that I am arguing is I am challenging the division bench court which basically set aside the decree which was in my favor.
That's not a substantial question of law.
Lordship, however, in the instant case, the substantial question of law being that it is against the principles of contractual law, more specifically when the party to a contract can invoke unilateral termination of the contract. In my humble opinion, that is a substantial question of law, Your Lordship.
We are examining this under what jurisdiction?
Under Article 136, Your Lordship.
So then how are we supposed to look at it?
Your Lordship, if I may state, the court is required to examine if the division bench's reasoning of setting aside the decree is right or not, Your Lordship.
Is that enough?
Your Lordship, and also to...
Under 136, you will have to convince us that there is a substantial question of law of public importance.
Indeed, Your Lordship.
The court might have committed an error, but still, why should we interfere?
I acknowledge, Lordship. However, in the instant case, since we are an aggrieved party and the deal was worth 1,200 crores and it was a share purchase agreement to acquire my company, therefore, I feel that it has a substantial effect on the industry, the hospitality industry in general, which warrants the interference of this court, Your Lordship.
Will that qualify as a question of law?
Lordship, this is the submission that the council has to make. Ultimately, it is for your Lordships to decide it.
Go ahead.
Lordship, moving on to the next fold of my argument, Your Lordship, which is to state that in the instant case, section 14, more specifically clause D, Lordship,
yes,
if you may have it.
Clause D.
It states that a contract which in its nature is determinable. Basically, this clause confers the power to the respondents to unilaterally terminate the contract. The council completely acknowledges that. However, as already established through my previous limb of the argument, that the conditions to invoke unilateral termination, more specifically, the material adverse impact has not been satisfied, because of which the respondents cannot claim unilateral termination of the contract. Therefore, this does not fall within the facets of 14D, and therefore it falls within the facet of section 10, wherein the specific relief must be ordered for and enforced, Lordship.
On what basis are you saying it's determinable, not determinable?
Your Lordship, I am not saying it's not determinable. I am saying that they do have a unilateral right to terminate the contract within the clause of the contract itself. However, what I am trying to state is...
Can you tell us on the basis of the termination clause?
Indeed, Your Lordship.
Interpret on termination clause.
Indeed, Your Lordship.
18. No?
Yes, Your Lordship. Clause 18. Either party may terminate this agreement for a breach by the other party of the conditions set out herein with 7 days notice. Further, captains in limited shall have a right to immediately terminate this agreement if, on the closing date, any of the conditions precedent to closing, that is in clause 7, remain unsatisfied and have not been waived in writing by captains in. Now, Your Lordship, if you look at the clause 7, which is the conditions precedent to closing, it clearly mentions that there must be no material adverse effect. Meaning, if they can establish and prove that there was a material adverse effect, then they can claim unilateral termination. But I have already proved to the best ability that there was no material adverse effect in order for them to claim the relief of unilateral termination, which is why it's my humble submission that it does not fall within the facet of 14 subclause D, and it should be enforced under the facet of section 10. If I may proceed with my further arguments. Much obliged, Lordship. Lordship, as I have already stated before, and I would like to reiterate, that in the instant case, the summer fest, while a significant factor, was just one revenue stream and the business has other income sources. This is because, Your Lordship, the respondent councils will rely on the fact...
Which point are you arguing now?
Lordship?
Which point have you taken up?
The third fold of my argument, to say that even if they consider that the Chaos in Champaner Fest, which was a summer edition of the fest, was a significant revenue stream for me, but that was only one revenue stream and I had multiple revenue streams. So that itself will not amount, or rather constitute a material adverse effect. So, Your Lordship, may I submit? Much obliged. Your Lordship, the council would... Yes. The council would like to submit that in the instant case, though COVID-19 was a major pandemic, but it was only a temporary setback. It was not a permanent one. Therefore, that itself did not limp or paralyze me of my ability to conduct future editions of the fest, or also to conduct a substituted edition of the fest, which is to say, instead of the summer edition, a winter edition of the fest. So that is my point number 1. Point number 2, Your Lordship, which is very important, the facts of the case. More specifically, if I may draw Your Lordship's attention to para 6 of the facts of the case, which clearly states that the 2 resorts owned by the petitioner in Champaner began receiving regular bookings. And the occupancy rate for the 2 properties as of June 2020 was only 14% lower compared to the 2019 figures. So this itself shows that despite the pandemic, my industry is reviving, and also it's a revival which is at a very substantial rate, because despite COVID, my bookings have only reduced by 14%. Therefore, it shows that the trajectory is towards an upward pattern and not towards a downward pattern. Therefore, it's my humble submission that we had multiple income sources, and even if they were here to contend that the fest was a significant part, but that itself does not constitute a material adverse effect.
But we can exercise the option of asking them to pay you some damages.
Indeed, Your Lordship. However, in the instant case, it's my humble submission that a compensation per se is not an adequate relief. Simply because, Your Lordship, if the share purchase agreement as it stands so is not enforced, it's the humble submission of the petitioner that would lead to an irreparable loss.
How?
Because, Your Lordship,
it's only a money matter.
Indeed, Your Lordship, but
you will get some kind of an interest for your investment.
Indeed. Lordship, the reason why the petitioner submits so is because from the facts of the case itself, it's very clearly revealed that after protracted negotiations for several months, and despite their several attempts to enter into the industry, more specifically into Champaner, we have arrived at this valuation of 1,200 crores. So, if this court were to uphold the decision of the division bench, or rather not enforce a specific performance, it would lead to a severe devaluation of our own shares, which would put us at a much worse place than we were before.
Why didn't you not pursue wrongful termination instead of specific performance?
Your Lordship, that is a very valid question. However, in the instant case, since the very contract also is covered within the facets of contractual law as well as the specific relief act, which is why we felt it would be an appropriate remedy if we pursued for specific performance over a wrongful termination.
That's why His Lordship is saying that you can be compensated for your loss.
Indeed, Your Lordship. However, we feel that justice would be done for both the parties if this very share purchase agreement as it stands so is enforced, Your Lordship. Indeed. Lordship, if I may proceed further, that this is my final submission as well, that the petitioner has always acted in good faith and has also been ready and willing at all times to perform the terms of the contract, especially the essential terms of the contract. This is because, Your Lordship, even from the very facts of the case, it can be seen that even till March, before the lockdown was imposed, we were in continuous negotiations with the government to ensure that the fest is conducted. However, something as unforeseen and unprecedented as COVID happened, because of which a subsequent lockdown was imposed. Therefore, that itself is not within the realm of our control. Whatever was within the realm of our control was performed, and we were ready and willing to also perform the same. Therefore, the council would like to rely on the principle of he who seeks equity must do equity, and therefore, when the plaintiff in the instant case has been able to showcase that he has been ready and willing to perform his terms of the contract, then I humbly oblige that this court upholds the decision of the single judge and enforces a decree for specific performance. It was an honor arguing before this bench, and if the bench doesn't have any other questions, the council would like to conclude his arguments.
Yeah,
it was an absolute honor, Lordship. I am much obliged.
Thank you very much. Focus on okay.
Only on the
Answer questions also. Okay.
May it please, my lords. I am Speaker 2 for the petitioner, and I shall be dealing with the substantive portion of our case before this Honourable Court today, which particularly deals with the challenge to the impugned provisions, which are mainly Section 5.2, Section 5.2 of the Bharatiya Telegraph Act.
Why did you come to us directly?
My lords, we believe that this particular issue involves a substantial question of law, which would warrant the interference of this court.
High Court can decide. 226 High Court can decide.
Agreed, my lords. The High Court can decide in this case. But, my lords, it's pertinent to mention that a similar question of law has been considered in a res integra manner in the case of PUCL versus Union of India.
Then all the more reason that the High Court should hear it.
My lords, we believe
precedent that we have to lay down.
Very well, my lords. But in this case, we believe that since this court has dealt with such similar issues on prior instances, we believe that it warrants the interference of this court in this particular case, not only because it involves the fundamental rights of my client, whose telephonic conversations were unlawfully tapped, but apart from that, it deals with the fundamental rights of each and every citizen of Bharat.
Why do you say unlawfully?
Milords, I shall proceed to establish this on 3 counts. So, Milords, my argument is essentially twofold. I shall proceed to show that these provisions are unconstitutional, dehouse the facts of the case, and additionally, I shall also go on to establish that if we do consider the facts of the case, the interception indeed was unlawful.
Is anyway unlawful.
Is anyway unlawful.
Correct.
Yes, Milords. Milords, the right to privacy is a fundamental right as established under Articles 19 and 21 of the Constitution, and as has been held in this court in the case of K.S. Puttaswamy versus Union of India. Essentially, Milords, the question that is before this court is whether the rights of the individual need to be balanced and in terms of ensuring essential procedural safeguards versus maintaining the rights of the state. It is contended and humbly conceded that while the right to privacy is not absolute, it is subject to reasonable restrictions imposed by government. In this case, Milords, we believe that the provisions that are being impugned do not have these reasonable restrictions, and I shall go on to demonstrate these. Essentially, my lord, just for convenience, my argument is going to be premised in a threefold manner. I'm going to test the constitutionality of these provisions based on Article 14, 19 Clause 2, the reasonable restrictions, as well as 21 of the Constitution.
Your challenge is to 5(2) and 69.
As well as the Telecommunications Act.
Okay.
So just for clarification, my lord, when this action took place, at that particular point of time, the Telegraph Act as well as the IT Act were in place. And since this action has been saved by the repealing clause in the Telecommunications Act, we are challenging the impugned provisions in its entirety. Milords, the first prong of my argument is that to invoke these provisions, what's important is that there should be an existence of a public emergency. That is exactly what the clauses stipulate. Section 5, Clause 2 of the Act states that on the occurrence, and if I may take my lords through it, on the occurrence of any public emergency or in the interest of the public safety, the central government or state government or any officer specially authorized in this behalf by the said government may, if satisfied that it is necessary or expedient to do so, record, I'm going to 3 lines after, may record in writing by order, direct that any message or class of messages to or from any person or class of persons.
What section you are referring to?
I'm referring to Section 5, Clause 2 of the the Bharatiya Telegraph Act, which is pari materia.
Correct.
Now, my lords, our contention in this case is that these provisions by themselves are in contravention to Part 3 of the Indian Constitution. The reason why we say so is because the Act, in its original form, when it was coming up in the year 1885, it lacked certain procedural safeguards. In fact, by the 38th Law Commission report, this particular provision said that instead of using the word may, which is an operative provision here, the term should have been may if necessary. If we read the provisions as it is, it leaves it to the subjective discretion of the officer in charge to make a determination as part of the executive whether they decide to exercise these laws and make subsequent interceptions.
What will be the implication of dropping that suggestion of the Law Commission?
The implication of dropping this suggestion, my lords, would be that this particular provision wouldn't be subject to a much stricter standard of scrutiny in this case, because in this case, we are balancing the private lives of individuals. So therefore, the threshold standard must be much higher in this case. In fact, my lords, at least Section 5, Clause 2...
Your argument is that even though the Parliament has dropped that,
Yes.
May, if necessary, was specifically dropped, nevertheless it will become unconstitutional because of Part 3.
It would become unconstitutional because of Part 3, apart from the fact that there are no clear definitions with respect to what exactly would constitute these particular criteria. For example, a public...
guiding principles.
There are no guiding
determining
principles.
necessity.
Milords, we fairly concede that this court, in the case of PUCL versus Union of India, has laid down 6 guiding principles.
Correct.
However, Milords, these were not incorporated in the statute. We fairly also concede that these were incorporated in Rule 419A of the IT rules. However, they do not form a part and parcel of the statute, therefore leaving it to the subjective discretion of the executive to make a determination as to what constitutes a public emergency. Now, my lords, if for a minute I might just apply these principles to the facts of the present case.
Right.
My lords, what has happened in this case is that the telephonic conversations between two individuals, one being a CEO and a chief minister, was intercepted. The facts are also undisputed on this point that the entire extract of the conversation was not released to the general public by the disclosure that was made by the Union Minister for Technology in his press conference. Now, if I might take, my lords, for a moment to paragraph 6 of the Moot problem. Because the key term, operative term over here, my lords, is whether there is a situation of public emergency or public safety. Now, I shall demonstrate as per the facts of the case that at that prevailing point of time, there was no need for the state to exercise its authority, as there was no situation requiring the interference because of public safety or public emergency. My lords, if I might read. Para 6, my lords may have it.
Sure, yeah, we got it.
By May 2020, the situation in Bharat had broadly stabilized as people learned to live with the COVID-19 virus. On 25th May, domestic flight services resumed. On 8th June, the Union Government of Bharat announced the reopening of malls, so-and-so, places of worship, subject to social distancing. My lords, it cannot be disputed that in this case, the scenario that existed at that point of time was substantially and materially...
You were talking about the economic scenario, but what they are speaking about is an issue of corruption.
Yes, my lords.
So it is in that context that the interruption has taken place. So therefore, the economic situation might have improved, but that will have no bearing on the character and conduct of the public officials. That is what perhaps provoked them to intercept. But provided they had any information, what kind of information? Perhaps they didn't have anything. You can elaborate.
Yes. My lords, in this case, I would fairly submit that while this call had been intercepted, it is still subject to investigation. Now, what I am trying to contend in this case is that the procedural safeguards as it stands today in the provision can only be attracted once this action has taken place. Now, this is an action of misuse of power, as we will try and demonstrate to my lords. However, what we are trying to contend is that there should be a probable cause in this case. Now, I use this term probable cause to refer to several jurisdictions in the Commonwealth which have used a particular statute which says that once a person's phone has to be intercepted or tapped, it requires the sanction of a prior judicial warrant. This is fairly accepted in the United States as well as other Commonwealth jurisdictions. We believe that the provisions as they stand today do not provide any pre-procedural safeguards prior to the interception itself. It might provide a criterion. It might state that the state can exercise its subjective discretion and then make a determination. But if my rights are infringed at this stage, my remedies can only come after the call has been intercepted.
Is there a judgment on this point, pre-procedural safeguard?
My lords, this was briefly discussed.
Where?
There is no binding judgment in this case, we'll fairly concede. But the case of PUCL versus Union of India discussed the standard of a reasonable cause in this case. And in fact, one of the submissions made by the petitioners in that case was that we could perhaps take a note from other jurisdictions, given that there seems to be an unfettered authority conferred upon the executive in this case, and perhaps enforce a prior judicial sanction. My lords, perhaps we might not even have to go into a judgment for that. Section 93 of the Code of Criminal Procedure provides for the issuance of a search warrant once they receive authorization by the court to compel the production of a document or any other thing. My lords, these are two very different legislations. The standard of scrutiny with respect to the impugned provisions in question is much higher because it requires the balancing of national security with the private lives of individuals. And the case of PUCL, as well as this court in a number of judgments, has laid down that telephonic conversations between two individuals in the privacy of their home cannot be intercepted unless they comply with procedural safeguards as per Article 14, 19 and 21. Essentially,
So your reference to 93 was in the context of what? That there should have been a judicial warrant for the interception, and the whole idea of an interception would become...
we believe so, my lords. Reason being that, my lords, in this case, the executive is empowered to make a subjective determination. I use the word subjective very specifically.
Isn't the immediacy lost if...
expedience, yes.
If a judicial warrant is issued for purposes of interception, something that is not part of the safeguards even propounded by PUCL?
My lords, I would refer to Justice Chelameshwar's decision in case Puttaswamy, where he said that such a determination must be made on a contextual basis of the case. In this case, I would fairly concede that the conversation was regarding the conduct of a festival, which could have perhaps flouted COVID-19 restrictions. However, in this case, since the bureaucracy is itself making this subjective determination, and then at the same time sitting as, I would go to the extent of saying, a judge on their own case, perhaps it would not be a stretch to say that it would require some form of judicial interference wherein an officer could make a determination as to whether or not such interference is required.
Are you drawing a distinction between warrant or advance notice as against the information that the government may subsequently give to the court about the provocation or pre-procedural safeguard? They will have to satisfy the court, is what you are saying.
Yes, my lords. In this case, what we are essentially trying to say is that
there is no such thing, is what?
Yes.
Well taken.
That's why there would be a requirement of pre-procedural safeguards.
What according to you is the best point that you can urge?
The best point that I could?
To enable us to quash the legislation, set aside the legislation. What is the best point at the top of your mind?
My lords, the best point that I could probably bring up to this court's notice is that apart from the fact that there is a lot of subjectivity left to these provisions, I would say in a nutshell that these provisions fail the four-pronged test as laid down by K.S. Puttaswamy in Union of India. My lords, the first prong of that test is that the state action must be sanctioned by law. There is a law in place. There is no doubt about that, and this is what we are hoping the court will indulge us with.
Okay.
Secondly, it says that there must be legitimate aim for action. What was the purpose of the Telegraph Act at the time of its inception? It was to ensure that the state has oversight over all regulations with respect to telecommunication. Now, if there is a law and order situation, there are other ancillary provisions that the state can use to make sure that there is legitimate aim for their action. Why intrude into the private lives of individuals, especially when there are no prior safeguards in place, and I can only pursue my remedies after the damage has been done? Thirdly, may I just take 2 minutes to conclude? Thank you so much. Third is that the action must be proportionate to the need for such interference.
Fourth,
and it's that it must be subject to certain procedural guarantees against the abuse of power, which we have contended is not present in this case. Therefore, not only is there ambiguity with respect to in what situations the executive can invoke these provisions, but it also fails this four-pronged test, thereby failing the...
You didn't tell us the fourth. Fourth one is the procedural guidelines, is it?
Yes, that's the one, my lord. The first one I couldn't contend because the state action must be sanctioned by law and the law is already in place, which is what we're hoping my lords will quash.
Thank you.
And lastly, that the facts of your case do not fall within the ambit of 5, because that's a stretch.
That's right, my lords. Because in this case, we believe that there was no situation warranting the interference of this act. Thank you so much, my lords. It was a pleasure arguing before this court.
Thank you.
Good afternoon, Lordships. May it please this court. I am Shayan Bhattacharya and I am appearing on behalf of Captain Inns Limited, the respondent in the special leave petition. My colleague Ankita Gupta is appearing on behalf of the Union of India in the writ petition. Now, I know my lords are well versed with the facts of the case, but I want to draw this bench's attention to a few facts which, in our opinion, decides the root of the controversy. Your Honours, I entered into a contract with them to buy their shares. On the date of signing, the only thing that I agreed to was that on a future date, I would transfer the money and they would transfer the shares to me if certain conditions are met. I want to emphasize here that no transfer of money or shares had been promised as an original intention unless the conditions were satisfied. In fact, the contract guarantees my immediate exit from the contract if the conditions are not met. This is the intention of the parties when they entered into the contract. Hence, we submit that the division bench of the Champaner High Court was correct in setting aside the specific performance of the share purchase.
What is the material adverse effect on you?
Your Honor,
Nothing.
Your Honor, I'll get into the material adverse effect. We submit, to summarize our submissions on material adverse effect, we say that we anticipated that COVID-19 would cause a durationally significant loss. I know at that point of time, it was only for 4 months when we exercised our termination, right? But we anticipated that the COVID would have a second wave, a third wave, which would have a large-scale repercussion in the hotel industry. And secondly, we anticipated that it would have a huge impact on our revenues, which is that the festival which we were very interested in, which is why we had resorts.
Anticipated loss is no ground for termination.
Your Honor, we didn't anticipate this loss. In fact, Your Honor, if I may submit that the pandemic was not anticipated by anyone. It happened, the pandemic
But you
happened.
just said you anticipated a second wave and the third wave.
Your Honor, after the COVID-19 started, when we entered into the contract, which is 12th of January 2020, at that point of time we couldn't know that the COVID would start. It started only in February and the impacts were felt later.
Yeah, go ahead.
Your Honor, I know that the petitioners have started with the material adverse effect, but I would like to start with my first submission, that the contract in the present case is determinable. My burden in front of this court is to satisfy either of the two arguments. If I am able to satisfy that, then the case doesn't stand. So on the first argument, that the SPA cannot be specifically enforceable as it is a determinable contract under Section 10, Section 14. Your Honor, Section 10 says that specific performance shall be enforced by the court subject to certain exceptions contained in 11(2), 14 and 16 of the specific relief act. The specific exceptions have been carved out by the legislature. Section 14D states that a contract that is in its nature determinable cannot be specifically enforced. Now, determinable is not defined anywhere in the act. So how do we determine what is determinable? The courts usually look at the termination clause of the contract in itself to determine it. Now I want to draw your lordship's attention to clause 18, which is the termination clause, which is available at page 2 of the Moot document. Two termination events are given. One is that if there's a breach by either party, then termination may be exercised. And the second is that I have an exclusive right to immediately exit the contract if the conditions are not met to my satisfaction.
What are those conditions?
The conditions are, they are condition precedents, and the condition precedent includes that a material adverse effect must not happen.
So they are interlinked.
No. Your later portion is that Captain Inns Limited shall have a right to immediately terminate if this agreement on the closing date, the conditions precedent to clause 7 remain unsatisfied. Tell us under 7 how they remain unsatisfied.
Your Honor, you are absolutely correct. Clause 7 talks about condition precedents, and one of the condition precedents is that a material adverse effect has to happen. Now, I may take your lordships to that very argument if that's what your lordship intends. Now, if we go to the definition of
material adverse effect, please read material adverse effect.
Material adverse effect means any event or circumstance.
No, here under 7.
7. Conditions precedent to closing.
You can't go to, for your purposes, you can't go to 2 definition of material effect. You must confine yourself to 7. You must satisfy us that 7 is satisfied.
Yes, Your Honor.
Clause 7. They shall, read that, they shall have.
Clause 7 stipulates that Captain Inn's obligations to complete the purchase of shares under the agreement shall be subject to the satisfaction of the following conditions.
Yes, read that.
And then it says, one of the condition precedents is that no material adverse effect. That is, there shall have been no event or change in circumstances that individually or in the aggregate has a material adverse effect on Raja Retreats Limited since the date of this agreement until the closing date. It is our submission, Your Honor, that a material adverse effect had happened because the agreement was signed.
What is that? What happened?
Your Honor,
On Raja. Raja is saying that it didn't happen, it didn't affect them.
Your Honor, Raja Retreats Limited themselves have agreed that the pandemic will have certain implications. It has been, we submit that we were primarily, when we were purchasing the property of Raja Retreats Limited, we were primarily interested in the Chaos and Champaner festival, which contributes to around 38% of revenue. And this entire Chaos and Champaner festival, Your Honor, was cancelled for the later duration of the...
Tell me, when did you terminate this agreement? 30th of March?
30th.
What was the condition that remained unsatisfied on the 30th of March?
Your Honor, the condition that remained unsatisfied was that a material adverse effect had happened. That's the only condition that remained.
But it's for them to say, right? They are saying we are happy with our work, our thing has improved.
It is, Your Honor, it's humbly submitted that it was to our satisfaction. If I may draw your attention to the termination clause.
Come, on the closing date, any conditions? No, not yet.
Remains unsatisfied and have not been waived in writing by Captain Lin.
Yes. Yeah. It has to be waived in writing by us. So it's to our satisfaction. If we do not waive it in writing, it's our intention that it has not been satisfied. And anyway, if you conjointly read it with our right to immediately terminate the agreement, it shows that very unilateral right that we have in this contract. And again, like I drew my Lordship's attention to the facts of the case, on the date of signing, our main concern was that all the conditions precedent would be satisfied. Only then we'll be exchanging the money and the shares.
So what you are arguing is that irrespective of what Raja says, you can draw the inference that it has materially affected him.
That's correct. That's my humble
According to you, the COVID situation has affected him.
That's correct.
Very
That's
well.
the humble
You can proceed to the next point.
Your Honor, the next point, as I was arguing previously, which was whether the contract is terminable or not, petitioners have drawn before this court certain case precedents. That I would like to draw this court's attention to this Supreme Court's case in Indian Oil Corporation. In Indian Oil Corporation, a 3-judge bench of this court in 1991. In that case, the contract had 2 termination clauses. First, contract could be terminated on occurrence of a breach, and second, the contract could be terminated without assigning any reasons. But the court, in its own wisdom, decided not to go into this distinction at all. They held that the contract was determinable, and they stopped there. Now, we cannot, of course, second guess and go back and say, this is the reason why the court did it, but they exercised their wisdom, and they decided not to go into that distinction.
That's not a precedent for you then.
Your Honor, even if that's the case, I would like to draw this court's attention to the fact that petitioners have tried to argue here that contracts could be put in 2 baskets. One is contracts which can be unilaterally terminated at the sweet will of a party, and then the second are contracts which can only be terminated on a breach occurring. I'd like to say that we fall into the 3rd basket because there's a distinction between contracts which can be terminated on the occurrence of a breach. You have a curing period to cure that breach that has happened, and then you can remedy it. But in this present case, that's not there. We have an immediate right to exit, which means that it's a forthwith and unilateral termination right that we have in the present case. I can draw, this distinction was also drawn by the Madras High Court in Jumbo World Holdings Limited. The Madras High Court categorized contracts into 5 different categories. They said that there are contracts which are terminable forthwith for cause, and there are contracts that are terminable for cause subject to breach notice and an opportunity to cure the breach. I humbly submit before this court that we fall into the earlier category, which is that a contract which is terminable forthwith for cause. And forthwith is what gives light to the intention of the parties. And we humbly submit that that has to be upheld in this present case. your Lordships have no further questions, I would like to summarize.
Yeah.
In conclusion, Your Honours, we argue that the present SLP is ought to be dismissed by this court by upholding the order of the division bench. The intention of the parties must be given effect to. Number one, the parties intended to give us the right to exit the contracts if the CPs were not satisfied to us. Further, we have argued that the termination was valid because a material adverse effect had occurred. This is because it had impacted Raja Retreat's revenue for a durationally significant period, which is that as we took a financial call that the COVID would last for the second and the third wave. And that is why we submit before this court that this contract shouldn't be specifically enforceable.
Thank you very much.
My lord, my lady, before I begin, a short case law compilation has been shared with the court master just for the convenience of the court. My lords, I am appearing on behalf of the Union of Bharat in the writ petition filed by Mr. Bhuvan Datta.
You have a tough job.
Yes, my lord.
Yes.
However, I will satisfy this court to the best of my ability. My lords, before I begin, it would be appropriate to point out to the bench that similar writ petitions challenging the same provisions that have been challenged by Mr. Bhuvan Datta are pending before this Honorable Supreme Court of Bharat. That is writ petition number 1 of 2019 and a batch of connected matters. In those cases as well, notice has been issued and pleadings stand complete.
We are not at the notice stage, we are finally.
Yes, my lords. So it may be assumed for all practical purposes that Mr. Bhuvan Datta's writ petition challenging the constitutionality of these provisions is part and parcel of that batch of matters. Having brought this to the bench's attention, I will move on with my substantive submissions. My lords, in every democracy, since time immemorial, some degree of interception powers have been granted to intelligence agencies and law enforcement agencies in certain exceptional circumstances. The Union does not contest the fact that citizens do have a constitutionally protected right to privacy. However, this right has to be understood in the context of the state's duty to protect its citizens in the face of modern dangers. And it is the Union's position that the current scheme created by the Telegraph Act, the Telecommunications Act, and the Information and Technology Act perfectly straddles this balance between ensuring the safety of citizens while also ensuring that the right to privacy is protected by several self-contained safeguards both in the statute as well as in the allied rules. I will make my argument, my lords, in two broad parts. First, preliminarily, I will submit that this is an already settled question of law in the case of PUCL versus Union of India, and there are no compelling reasons for this court to reconsider that decision. Secondly, my lords, on merits, I will submit that, that the scheme created by these acts constitutes a valid restriction on the right to privacy and meets the proportionality test laid down by this court in the case of Puttaswamy. But before I get into my substantive arguments, my lord, a small clarification on the text of Section 5 of the Telegraph Act that the Learned Counsel referred to. My lords, it does not grant discretion without a cause to the executive. If I read the section, it says, on the occurrence of any public emergency or in the interest of public safety, the central government or the state government may, if satisfied that it is necessary or expedient to do so. So the requirement of necessity and expediency continues to exist in the statute.
What was that?
What was
on
that?
fact?
My lords, a two-pronged response to that. Firstly, my lords, what has been challenged by Mr. Bhuvan Datta is the constitutionality of the provisions themselves. In case Mr. Bhuvan Datta believes that the interception has happened illegally, he has remedies under Section 25 of the Telegraph Act, which deals with illegal interception.
Notwithstanding that, what was a compelling interest that required you to intercept in this case?
Absolutely, my lord. My lord, the statute requires two things. Firstly, it requires us to have a prerequisite of public emergency or public safety, followed by the interception having to be on the grounds laid down in Section 5.2, which mirror the grounds under Article 19.2. The way the term public emergency has been interpreted by the courts is found in the case of PUCL versus Union of India, where the court has interpreted public emergency to not just mean any form of emergency such as an economic emergency, but a very particularly grey form of emergency. In the present case, the country was going through a raving pandemic. There were huge public health concerns in mind, and it was in that context that the union government found it necessary and expedient to exercise its powers. However, my lord, I must point out that under both Rule 419A as well as the statute, the actions of the executive and the interception orders cannot be challenged. And in fact, for that very same reason, they have not been challenged by the petitioner as well. The only challenge made by the petitioner is to the constitutionality of the provisions themselves and not the application of this statute in a particular factual circumstance. So if I could satisfy my lords on the constitutionality of the provisions themselves.
Tell us.
Yes, my lords. My lords, because in the, my lords, just one last point before I move to that, because in the specific context of the facts, there are already self-contained safeguards. There is a review committee which will look at the interception order and check whether it complies with the provisions of section 5.2 or not.
By which time damage will be done.
My lords, the review committee has the power to not only set aside the order, but also order for destruction of all the data that has been intercepted by intercepted pursuant to that order.
It's already been circulated and everybody has
My
seen
lords,
it. What remedy does?
my lords, the fact that a media outlet got access to that information is something that is subject to investigation. And again, the petitioners may use may invoke Section 25 of the Telegraph Act to challenge how the media outlet got access to that.
They could have got access only from you.
My lords, that is a subject of investigation and does not bear on the constitutionality of the provisions themselves. So if I could satisfy my lords on the constitutionality of the provisions. My first argument is that this is re-agitating a settled question of law. I must clarify, my lords, what happened in the case of PUCL versus Union of India. In the case of PUCL, a two-judge bench of this court upheld the constitutionality of Section 5.2 of the Telegraph Act. At that time, back in 1997, the government had not enacted any allied rules, which is why the court found that there might be some procedural directions that they should give in the interim. After PUCL was passed, the executive has enacted Rule 419A of the Telegraph Act, which contains not only the safeguards in PUCL, but also a host of other safeguards. And therefore, this question of the constitutionality of the substantive provisions is already settled. In fact, my lords, in the case of Puttaswamy versus Union of India, it was PUCL versus Union of India that was quoted with approval and formed an integral part of us locating our right to privacy. And therefore, there are no compelling reasons for us to turn back and again reconsider the question of law settled in PUCL versus Union of India. My lords, moving on to my submission on merits. It is the union's submission that the scheme created by these acts meets the proportionality test. I will not take my lords through how the proportionality test came into being and the various formulations. I will rely on the precise formulation given by Justice Sikri in the case of Puttaswamy 2. If my lords refer to paragraph 319 of the judgment, it's at PDF page 1339, a four-pronged test was laid down. Firstly, the measure restricting the right must have a legitimate goal, that is, there must be a legitimate state interest. Secondly, it must be a suitable means of furthering this goal, that is, there should be a rational connection. Third, there must not be any less restrictive but equally effective alternative. And finally, the measure must not have a disproportionate impact on the right holder. That is the balancing stage of the test. My lords, it is a well-accepted position of law.
Can you make your submission without using the expression, my lord?
Absolutely. It is a well-settled position of law that public safety, national security, crime control constitute legitimate goals. This was recognized in the case of Puttaswamy 1 as well. Justice Chandrachud, as a learned Chief Justice then has recognized as national security is a valid state interest at paragraphs 309 to 311, which has also been echoed by the other judgments in the case as well. So the first test is undoubtedly satisfied, that is, that there is a legitimate state goal. The second is whether there is a rational connection between this state interest and the actions of surveillance. Undoubtedly, my lords, it is our submission that there is. In certain circumstances, intelligence agencies and law enforcement agencies need to intercept messages for prevention.
What's the connection?
My lords, in certain cases, interception assists the enforcement agencies in conducting investigation, prevention, and also in ensuring risk assessment.
What was the investigation you were conducting?
My lords, in the facts of this present case, my lords, there are certain allegations of corruption that are being investigated, but again, my lords, these are matters of investigation and not subject to judicial review, at least at this stage, when the constitutionality of the provisions are being challenged. My lords, now coming to the thorny parts of this test, which is the necessity stage and the balancing stage. The necessity stage broadly means that there must not be any less restrictive but not equally effective alternative. The way the necessity stage has been interpreted by the courts is important. Justice Sikri in Puttaswamy 2 was clear that to satisfy the necessity test, one does not need to prove that what the government is using is the least intrusive measure or that there is any
Counsel,
measure.
we have a strong suspicion that the government has taken it up for political reasons.
My lords, in the present, again, if you are referring to the
Doesn't,
present factual.
see, that itself shows that the provisions have been misused.
My lords, it is a submission.
How can the government?
And which
Take
part of
up
5.2 are you invoking to intercept a conversation like this? How does it pass that test?
My lords, it is our submission that the interception in the present factual situation was done under Section 5.2 of the Telegraph Act as well as Section 69 of the IT Act. The IT Act mirrors the provisions of Section 5.2 with an added ground, that is investigation of any offence when the government believes it's necessary and expedient to do so. So it is under that ground that they
More of a fishing and roving inquiry, isn't it? Where is the basis for such an interception?
My lords, again, in this present in the factual circumstances of the interception that has come out in the media, it is subject to the review committee checking whether it was in compliance with Section 5.2 and Section 69. And the review committee is mandated to ensure that it is in compliance with these provisions. If the review committee constituted under Rule 419A believes that it does not comply with these provisions, the order will be set aside.
Are there any loose ends in the statutory provisions as government you would suggest that bring it in the subordinate legislation?
My lords, it is our submission that as the subordinate legislation stands currently, it is the most effective way of conducting surveillance while also ensuring that the right to privacy remains protected. My lords, because three things are required when it comes to surveillance. That is exactitude, speed and utmost secrecy. And it is our submission that any other alternative, be it things like judicial scrutiny that was suggested by the Learned Counsel, would not be able to meet these three requirements.
But have they been met now?
Yes, my lords. It is our submission that the present procedural safeguards, which is that A, the order has to be in writing, B, the order has to be on very narrowly specified grounds, 3, this order has to be mandatorily sent to a review committee, 4, this order must clearly state reasons as to why this information could not be brought in any other manner, could not have been received by the government in any other manner, and 5th, the review committee has the power to set this aside. And my lords, if I could take you through a few more.
Does the appellant or anyone else get an opportunity to read this order?
No, my lords.
Do you ever share this order post the interception with them?
No, my lords. And that, my lords, is in the interest of secrecy, that the order is not shared with the subject of surveillance. My lords, because the point of surveillance will be defeated if the subject of surveillance is aware that
The surveillance is done post facto.
My lords, but the fact that the surveillance was done, the information collected during, the fact that the surveillance was done is an important data point for our law enforcement agencies, which cannot be revealed to the subject of surveillance themselves. In fact, my
You will
lords,
disclose it to the court?
my lords,
Or you will seek immunity?
my lords, under the current statutory schemes and the rules, the data is only, the interception order is only revealed to the review committee, and that is also, my lords, in the interest of secrecy and in the interest of the right to privacy as well. Which is why, my lords, the interception is for a time-bound period, first for 80 days, and it may be extended up to 180 days. And after the interception is complete, all the information as well as the order is immediately destructed, which ensures that both the privacy of the individual is maintained, while also ensuring that
The privacy was clearly not maintained in this case. The order was shared with the media, and the media did expose. So where was the privacy?
My lords, I fairly concede from the Union of India that the media getting access to the telephone call, provided that was actually a call that was intercepted, was a lapse in the procedure as it stands. But I believe that one case of potential misuse cannot be a ground to challenge the constitutionality of the procedure itself. And therefore, my lords, I would like to satisfy you on the constitutionality of the provisions itself. So my lords, having satisfied you on the third prong, which is that there is no other equally effective alternative that is less intrusive, we finally come to the last prong, which is that of balancing. That is whether there is any disproportionate impact on the right. If my lords look at Rule 419A, you will find it at page 2. If I could just get a minute, my lords. On page 2 of our compilation, there are 19 procedural safeguards that are in place to ensure that the right to privacy is not unnecessarily violated. Moreover, my lord, just to clarify, when my learned counsel states that things like public emergency and public safety are broad terms and therefore they are overbroad phrases that should be struck down under Article 19, it's important for us to recognize how these phrases have been interpreted by the courts. If I could quickly read a paragraph from the case of PUCL versus Union of India. The court relies on the decision in Hukum Chand Shamlal versus Union of India to understand what a public emergency and what public safety really is. The court says, as a preliminary step to the exercise of further jurisdiction, under this section, the government or the authority concerned must record its satisfaction as to the existence of some emergency. Further, the existence of the emergency, which is a prerequisite for the exercise of power under this section, must be a public emergency and not any other kind of emergency. The expression public emergency has not been defined in the statute, but contours broadly delineating its scope are discernible from the section, which has to be read as a whole. In subsection 1, the phrase occurrence of any public emergency is connected with and is immediately followed by
What is the
phrase,
public emergency here?
My lords, it is our submission that...
Pandemic.
Yes,
But
my
that
lord.
will have no bearing on
a conversation.
on intercepting.
My lords, the fact that there was a public health crisis caused by the pandemic does mean that there was a public emergency. However, this is only
So
step
whenever there
one.
is a public emergency like COVID, you will start intercepting
No,
all
my
calls.
That is only step
Then
one
why
of what
don't
the
you do it?
statute provides. Step 2 is that even if there is a public emergency, that does not mean we can surveil anyone. Even then, the order has to satisfy that it was necessary and expedient to do so in the interest of sovereignty and integrity, public order, and so on.
So how do you
of which,
satisfy step 2?
all of which are grounds that mirror Article 19.2. My lords, again, these are, the order is not, we don't have the benefit of having the order of the Home Secretary with us today. However, in case it is found that it does not comply with Section 5.2 and it has not met the procedural safeguards of 419, the review committee will set it aside, my lords. I can assure you that the review committee, constituted of high-ranking officials of the government, will ensure that the contours of Section 5.2 are satisfied.
We also have some information that the review committee is overburdened with so many interception orders and it is incapable of setting aside any of them without just mechanically doing that.
My lords, at the level of the union government, efforts will be made to ensure that the review committee can work more efficiently. But as things stand, given the importance of
That is your big point, no? That the review committee will set it aside if it is found to be.
ma'am.
But the review committee itself is functioning mechanically. So is that an adequate safeguard?
My lords, it is our submission that the review committee as it stands is not functioning mechanically. It consists of very high-ranking officials of the government, such as the cabinet secretary, the secretary to the government of India, legal affairs, and so on. And these are not authorities who will merely rubber stamp an order. They are mandated under Rule 419A to ensure that it is in compliance with 5.2, and more importantly, this information could not be brought in any other manner. Therefore, the proportionality analysis is also conducted within the government as well.
Thank you.
Thank you, my lords.
Is there a rejoinder? They are given.
Council wants seeks permission of
Yes,
coordinate
yes.
to rebut issue 1 and my co-counsel rebut issue 2. Lordship, when the respondent counsel submitted his arguments, he said that they anticipated COVID and multiple COVID waves. But if you look at the very clause in the contract, it says material adverse effect are those circumstances which the parties would reasonably expect. So I think it is fair to state that none of us reasonably expected something such as COVID. And Your Lordship, what needs to be further read is that that very clause excludes governmental actions. So we have already submitted before you that the very lockdown itself was a governmental action. Therefore, they have not satisfied this court as to how that lockdown and subsequent cancellation stands within clause 2, subclause 2. The next rebuttal is that, Lordship, ultimately the contract was to acquire shares but not to conduct the fest. But the very argument of the respondents have been surmised on the basis that the fest was not conducted, which is a material adverse effect. Lordship, thirdly, we have not denied that the contract is determinable. In fact, I fairly conceded to this court as well. But what we are again reiterating is that they have not satisfied that the conditions to justify the termination is fulfilled in the instant case. Lordship, fourthly, and most importantly, there was a judgment of the US Supreme Court in the case of US versus Delaware. I know it's not binding on you, but it says that a short-term hiccup in earning does not constitute a material adverse effect. It should be something which is material and viewed from a long-term perspective. As I have already submitted, COVID was ultimately a temporary setback. It was not a permanent setback which paralyzed us of our ability to conduct future editions of the fest. So that should be viewed by the respondents. And finally, Your Lordship, they have also again not acknowledged and answered a question that we were ready and willing to perform the contract to the best of our ability and circumstances which were within our control. COVID was something unforeseen, unprecedented, and completely not within the control of anybody. Therefore, this is my humble submission. And it was again an honor arguing before this bench.
Thank you very much.
Thank you.
Lords, before we came into this dispute today, we believed that perhaps we might have a cause and not a case, but today we certainly believe that we have both. And to that effect, I'll make 3 quick submissions. The judgment referred to them, PUCL, says that there was no compelling reason and that it upheld the constitutionality of these provisions. But what also must be mentioned is that the PUCL court also clearly stated that there are no procedural safeguards, which is why it went down to lay that 6-fold test, which we would also say is not something which enforcement agencies have been complying with. Apart from that, our remedy under Section 25 of the Telegraph Act is something which comes in at an ex post facto stage. What happens at a preliminary stage? Those procedural safeguards are something that the respondents have been silent on so far. Apart from that, the 4-pronged stage that they mentioned, we would categorically like to contend that one cannot cherry pick in this case. While there might be legitimate state action, one must also ensure that the other 3 important prongs of these tests are met. And what we have contended time and time again throughout is that there were no preliminary procedural safeguards warranting interference of the state into the private lives of these individuals. An other observation which fell from my lords is that the orders in this case are not shown to the persons who are at the receiving end of it. My lords, it's commonplace, especially in our statutory provisions, for example in the Coffee Posa Act, that the person, the detainee in that particular case is served with a written copy of the order. My lords, they mentioned secrecy. We must say that there is a fine line of, may I just take 10 seconds to summarize? There's a fine line, there's a very big line of difference between secrecy and confidentiality. Confidentiality is something that can be maintained. Secrecy is the withholding of information, and certainly when my client is at the receiving end of it, there shouldn't be secrecy in this case. And lastly, my lord, we'd like to mention that they have not shown...
Any other judgment talked about confidentiality?
My lords, unfortunately...
Ratan Tata?
Yes, apologies, my lords. With respect to that, my lords, the difference between the two is that confidentiality can be maintained, giving the other side an opportunity to respond to the allegations against them. But when we have an element of secrecy, we are basically not affording the other side to respond to the averments or allegations that are made against them. And lastly, to this effect, my lords, we would like to state that not every condition involving public safety as contemplated by the Law Commission, the 38th Law Commission, not every situation of public safety would escalate into a case of public emergency, which is why the specific provisions of the Telegraph Act use them separately. So we might have a case where public safety is in question, but not necessarily leading to an emergency. And specifically in this case, given the prevailing circumstances at the time, there was no proclamation made by the government that there was a public emergency in place, which is why we would humbly hope that this court rules these provisions to be unconstitutional. Thank you very much for your time.
Lordships, I'll be taking 2 minutes rebutting the first issue and my co-counsel will be taking 2 minutes rebutting the second issue. Lordships, at the very beginning of my argument, I clarified our burden. Our burden was not to prove that both the issues, that is, whether the contract was determinable and whether the termination was valid. We just had to prove that one of them was not done for specific performance to happen. They had to prove that both were not done. Now, counsel for respondent came here and they conceded that the contract conceded on determinability. Now, if I may read out Section 10 for the Lordship's clarity, Section 10 states that the specific performance of a contract shall be enforced by the court subject to provisions contained in 11(2), 14 and 16. Now, since the contract is determinable in nature, the case doesn't stand. But in any case, counsel for respondents also said that we had kind of anticipated COVID. I had clarified this during my submissions. I said that we could not have possibly anticipated because the agreement was signed on 12th of January 2020. COVID started in February and the agreement was terminated in 30th of March 2020. With these, I rest my rebuttals.
My lords, in Sir rebuttal, I'll just respond to the 2 points that were raised by the learned counsel in his rebuttal. Firstly, I submit that the reliance on PUCL by the petitioners is slightly erroneous and misplaced. Because in PUCL, the substantive provisions of Section 5(2) were upheld. Yes, the court recognized that it lacked procedural safeguards, but that was back at a time when there were no rules in place. And the court made certain interim guidelines, all of which have been incorporated in Rule 419A. So the executive has gone way beyond PUCL in ensuring the constitutionality of the provision. The fact that they're not actually complying with it is whether or not they're actually complying with these procedural safeguards is a separate question, and that does not change the fact that PUCL is a settled law on this question. The second thing, my lords, is that under the necessity test, it is the petitioner's burden to provide us with certain less restrictive alternatives. The only alternative that the petitioners have provided us here is give them a prior hearing. My lords, as stated before, this alternative also has to meet the requirements of a surveillance regime in a real and substantial manner. In the case of Anuradha Bhasin versus Union of India, this court made 2 important notes of caution when it comes to the petitioners providing alternatives. It was A, this must meet it in a real and substantial manner. Merely giving us a less drastic alternative will not do the trick. Secondly, it must be in such a manner that that the wisdom of the legislature in enacting these statutes is not overridden. Now, my lords, as stated before, to meet the necessity test, any alternative would have to ensure within its fold secrecy as well as speed. When you give a person who is a subject of surveillance a prior hearing, both secrecy and speed are compromised. And therefore, the third prong is satisfied on that regard itself, and no alternative has been provided to us by the petitioner. And the way the test has been formulated, it is the burden of the petitioner to provide an equally effective but less restrictive alternative.
Thank you. Thank you. We'll conclude the hearing.
We just request the judges to stay on the dais. So I can request the teams to step outside briefly while the judges are in conference. And we can discuss amongst yourselves.
You can sit. Why all so many of them are there? Then we'll come back. Where's your teammate? We'll wait. He'll come, relax. See, even you couldn't prevent using my lordship. It gets into you so much that you can't get out of it.
Maybe you can start with the feedback and then we can announce the results.
Wait. You know, the tough difficulty in decision making, even for a judge, is not to be influenced by the case or the cause. We are not judging today the case. We are judging
Advocacy.
the advocacy. That's the art. That's an art. It's not consistent. It moves from case to case. All of us know that in a case you yourself evaluate your own performance, and you will be very happy in some cases. You walk into the next case, you will come out saying that what the hell, why did I argue like this? You don't know, because very many factors vary from time to time, case to case, time, and also judge to judge. Perhaps some nervousness before some judge, before some other judge, he'll put you at ease. Such things happen, and you will learn by the time, step by step. And it's one of the greatest arts that anybody can perform. Even as a judge now, I recall my days as a lawyer, and so thrilling it were. And as far as for me, this is the greatest thing that you can do. What you do, actually, you sell an idea. You have to convince a judge on law, on very many things. It's not just the interpretation that matters. You need to know the mind of the judge. You need to watch your language, your demeanor. All these things come to you by experience. It's an excellent job. And we were just discussing, it's so difficult for us to choose between both the teams, because your performance was very good at par. And one good thing which I've seen is that shows the ability of lawyer, that you perform and you keep improving upon it. And both of you, both sides,
Came back very strongly.
You came back. That means you are watching the other person arguing. You found what is the weakness. You came back to answer that point. So it's a very good thing. Congratulating all of you. Decision had to be taken, so decision is taken. This has nothing to do with performance as such. All of you at par, definitely. Amongst the speakers, we thought the best speaker could be Raghav Sen Gupta. And big applause for him. And so far as the team is concerned, I think joint effort of the team is Team 6 of who had performed. So that way, excellent teamwork. You've as a team, the way you came back with the submissions
Rebuttals
made by them in the rebuttal was excellent. Very good. So we congratulate all of you. All the very best. My friend will say something.
Both of us were actually classmates in college.
Sit down.
But please sit down.
We'll spend some time.
I was very impressed by the standards of advocacy. What was said just now, that you're selling an idea. Actually, as a practitioner of criminal law, I feel I sell a story, because when I listen to my clients, it is their story that I put forward in a court of law. And some of those stories are very dark stories. And to say it in a way which is compassionate, advocacy is also about compassion. It's also about empathy, understanding from where. It's about rules, it's about statutes, it's about placing your case within the four corners of that statute, but ultimately it's also about empathy. And I hope as you practice more and as you come forward as the generation that we will be looking forward to watching, you will also in your address to courts put forth that empathy, because that without empathy you are not really, you're not going to be, that's the difference between great lawyers and ordinary lawyers.
So criminal lawyer, no? She speaks of empathy. A constitutional administrative lawyer will think of craft, will think of interpretation, and
Yes.
remember, all of you, your role is not in any way different from that of a judge. As a lawyer, you have limits of your submission. You always have limits, that far and no further. You do it, you might not realize. That is where your responsibility lies, not to place before a court an unreasonable argument, an absurd argument. In the ultimate analysis, we are all part of the same system.
Correct.
Where we are providing justice, because a judge can't do it by himself. He needs to rely on the lawyers who are representing on either side. And the reason being that we really don't know where the truth lies. Judge doesn't have any divine blessing to know where the truth is. It's probability. So how does the probability occur? It occurs because we now have the opportunity of seeing two perspectives, and we will pick up whichever we think is closest to the truth. Now you see how important your roles are. And at the same time, making a submission which is reasonable, and a submission which enables the court to arrive at a correct decision is extremely important. Your roles are in no way different from that of a judge. That's my belief. And she does it day in and day out in so many cases. So, anything more?
That's it. We found it an extremely, it was a pleasure listening to all of you. Congratulations. And just because we've named one a winner, it is no reflection on your individual skills. Thank you very much.
Thank you. Thank you.
Please remain where you are right now. We'd first like to thank our judges for both taking the time out on a Sunday morning to host this competition, and also for just imparting their wisdom with our law clerks. We'd just like to get a quick set of photographs. If I could request Raghav to come, and Ms. Rebecca John, if you can hand over the best speaker and final trophy.
Sure.
If you can join him, we'll do the runners-up trophy.
Come.
If you could do the runners-up, then
Come, Shashi.
Close call. You were also very, very good. You came back very strongly.
Excellent.
Thank you. Now, if we can ask the winning team to come. Sir, can I ask you something?
Come. Team of three. Very good.
As I told them, it was very close.
Group photo, okay.
If you can get the both.
Come. Group photo. हम बैठे all of you come. All of you participants? Okay.
The others have left.
Others have left? Yeah. Why did you also join us? Please come, Hurry. We didn't see that. Come. Yeah, very good. Yeah. You'll also stand. Come. Yes. One. चलो come. ठीक है. Come.
Chachi.
कुछ लोग, some people.
कुछ लोग इधर आ जाओ.
Okay? Some more. Right.
Come, I'm
Wait
fine.
a minute. Are you?
Are you?
You come in the front. Come here.
You're not visible.
Come here. Just stand here because they are in the team.
सब
Right.
दिख रहे हैं. I told us.
क्या कहना चाहते हैं?
Shorter people in front. That's better.
Thank you.
Now just the teams, you know, with judges.
Okay. Just the team. The two teams? Okay.
Who's not made it
When is the third?
finals, guys?
So we are only 2 members.
Oh.
You come on. You
Aage?
participated. Who
Come in the front.
participated?
Thank
Thank you. Thank you.
Thank you, ma'am.
Thank you very much.
I just wanted to say I'm clerking now because I had interned with your office back in 2022.
When you
I used to come to the Noida office.
Ah.
I was there when you were walking.
Check. Absolutely. Check.
Around me if it
It's a transfer petition, your lordship seeking
just give us
transfer.
a moment. Just 1 second.
Yes.
This is from the family court at Bhavnagar to
Bhopal.
family court at Bhopal.
The notice has been issued, no one has entered appearance, lordship. He is admitted in New Zealand, he is not in India.
Well, I have the transfer.
He is in New Zealand.
Manoj? Transfer.
I'm grateful.
Mediation has failed, right?
Yes, madam.
But why do you want a transfer from Gurgaon to
No, it's
Gurgaon
because-
to
yes.
Patiala House? You
Yes,
can surely, I
because-
mean, people keep on driving to go and eat food in a restaurant, and you can't come for your own matter.
No,
Lord, even otherwise, if my lords may
unfortunately,
consider,
the
I
VC
appear for the
VC
respondent.
hearing is not even working in Gurugram. In Delhi, all the family courts, the VC hearings are working absolutely fine.
But you
And-
have to go from Golf Links, where your house is, to Gurugram. Don't
Yeah.
tell me you don't go to Gurugram at all.
Well, there are 3 cases that
Even otherwise, my lords.
including a civil suit filed by the father-in-law, and there is a divorce case filed by the wife.
My lord, there is, my father filed a civil suit, my lord. My father filed a 200 CRPC.
There's a-
My mother's filed a DV, which is also pending in the same Gurgaon court, my lords. This is nothing but a harassment tactic. Even otherwise, my lords, may kindly consider this.
Mr. Agarwala, who are you appearing for?
Lords, I appear for the respondent in the matter, my lords.
Wait for until you're called upon. Yes,
So
what do you have to
sorry.
say?
Similar,
Sorry, my
in
lord.
this
Sorry.
particular
Sorry.
case, what
Otherwise,
has
we might be actually constrained to transfer the proceeding. Yes.
I'm sorry. I'm sorry.
Unfortunately, what has happened is we filed a domestic violence case here. We filed an FIR here in Delhi, my lords. They filed a divorce petition and the father-in-law filed a civil suit for damages. The mother-in-law has filed a DV case. They're just browbeating us with litigation over there in Gurugram. And interestingly,
You know, the only thing is that these are virtually it's part of Delhi. I mean, it's a suburb, and And there also, suppose we have occasionally transferred proceedings. Suppose there's a small child, a woman who's staying alone. We'll do that. But you also that you're wanting.
She's suffering from pelvic inflammatory disease.
From golf links to Gurugram is not
Well,
that.
pelvic inflammatory disease she's suffering from. And another difficulty that we face is all appeals from family court will go to Punjab and Haryana High Court, my lord. My difficulty is here we are before the Honorable Delhi High Court itself. And the VC hearings they are not providing us. We could have.
At that stage, if you want, you can apply for transfer. Let the appeal be transferred to the Delhi High Court. Who knows? You may not have to file an appeal.
My lord, that would be if it could be reflected then in the order, my lord, because in the appeal cases, my lord, they will not. Once I face the trial there.
All right, now let's hear Mr. Agarwal.
Just one line. I just make most cases now pending in the family court Patiala House. They have also filed. I'm seeking divorce transfer to the Delhi court, my lord. I filed it subsequently.
You have also filed.
Yes, my lord, in Patiala House Courts, Delhi. My DV case is in Delhi. My FIR charge sheet is in Delhi, my lord. 3 cases are in Delhi.
When did he file his divorce petition?
My lord, he filed it prior in point of time.
When?
So
when?
2 years prior, my lord.
13th January 2023, my lord.
And what about
21?
And what about you?
My lord, in 23, my lord.
During pendency of
After filing this transfer petition, my
18
lord.
September 23, my lord.
My lords, after
no
filing this
submission
transfer
is-
petition, my lords.
Yes.
We can transfer your petition if you want to Gurugram, so that
Well,
both
my-
can be heard together.
My lord,
Lords,
only
my matter
difficulty
is
I
that
have
the petitioner
explained.
All right,
evidence
let
states,
Mr. Agarwal.
my
Mr. Agarwal has been very keen to.
lords,
let us
just
hear.
one
Yes,
small
Mr.
thing that I
Agarwal.
wish to point, my lords, just one small thing that I wanted to point, my lords. They have entered appearance. They've been contesting this matter for the past 2 years, my lords. And it is only, my lords, after filing this transfer petition that the lady has moved now a divorce petition in Patiala House Courts, my lords. And now the matter in Gurgaon, my lords, is already listed for petitioner evidence. At that stage, they want to come over here and, my lord, come here and do what, my lord? Just delay proceedings and do nothing else, my lords. That's the only thing I wanted to point out, my lords.
Yes, it is.
With regard to, I'm also suffering from PID, my lord.
Item 3.
Very good.
This is from the family court at Thane to the East District Saket Court, right?
Lordship, both husband and wife are residing together in this matter, madam. They are residing together from the last date of hearing as well. They were together.
Then you can withdraw this matter.
My lord, I am for the respondent here,
My lords, I am appearing for the petitioner in the matter, my lords. I have instructions to withdraw the petition.
Item 4. Grateful.
Most obliged.
Dismissed with withdrawn.
With the petition.
That's it.
That's it.
Which is in.
Was it beg to pay for the respondent?
Petitioner?
Petitioner,
Petitioner. Let's say petitioner is needy and very poor family background and residing along with her widow mother, Your Lordship, or distance between Muzaffarpur to Ludhiana 1,230 kilometers, Your Lordship, and petitioner has not any source of income, Your Lordship.
My lords, if I may point out, my lords, I am beg to pay for the respondent. My lords, I have been engaged through the Supreme Court Legal Services Committee. He is presently unemployed. There are 2 proceedings in Bihar. He has filed 1 suit in Ludhiana. My lords, let her bear the cost for the proceedings in Ludhiana, and I'll bear the cost for attending proceedings in Muzaffarpur. Because I am also, my lords, living with my old parents. I am the only breadwinner, and now I am
You have
unemployed.
also come, your client has come through legal aid.
My lords.
Do is that we will not transfer the suit, but we'll permit you to appear through video conferencing.
Obliged, Your Lord.
So dismiss, but permitted to the usual order for.
My lords, will the respondent also be permitted to appear through video conferencing in the 2 cases in Muzaffarpur, Bihar? Would my lords also?
No objection, Your Lordship.
There's nothing here before us today.
Very well. I understand.
That he can apply, actually. You
I'll
can
apply.
apply.
So I'll-
Item 5.
Grateful, my lords.
Please, Your Lordship.
Transfer of a 138 complete. Service is not complete.
Your Lordship, service has been completed to respondent number 1. However, the respondent number 2 has not been.
So you serve respondent number 2 and.
Your Lordship, the respondent number 2 has already been served, and
No, but there's office report says R2 is not served.
these 2 matters are different, my lords. The one matter has been filed by the respondent number 1 in Guhana district, and the respondent number 2 has
In Jhajjar.
filed in the Jhajjar districts, my lord.
Only a question of only service, because if you transfer it, there'll be a problem. They'll say that I was never even told about this transfer.
Your Lordship, as
Why
per
don't you
the
serve him and come?
as per the given address, we have served it. As per the given address in the summon and in the petition, my lords, I have served it.
Given address means what?
The address in which the summon I have received from the court, and the
He says he has typed.
yeah, so,
Is that the check was stolen, is it?
yes, my lords, and FIR has already been registered against in that allegation, my lord.
No, but ultimately, the thing is that, is this a case for transfer?
Your lordship may see on page number
All your
17, my lord.
defenses you will have to urge really in because the check has been dishonored in the place where it
Your
was
lordship,
presented.
if your lordship see, even in the complaint, the checks has been taken in Delhi only. If the respondent thing is seen to be true, the respondent claims that the check has been taken in Delhi only. However, he deposited that check in Gohana and in different districts just to harass me. There are, if your lordship see, on page number
What should we do?
46, Annexure 6. Your lordship, there has been an order.
Ask them to serve R2 through the station house officer to the SHO.
Please,
The
Your
office report
Your lordship.
indicates, one second, the office report indicates that the second respondent is unserved. Next, Learned Counsel for the petitioner submits that the service has been, that the address has mentioned. Office report indicates that the second respondent is unserved due to, into inverted commas, insufficient address. Next, Learned Counsel for the petitioner, on the other hand, submits that the address which is indicated in the cause title of the transfer petition is the same address as indicated in the summons which has been received by the petitioner.
Absolutely.
In the above circumstances, we direct that the second respondent be served with notice through the SHO of the police station concerned. Full stop. A fresh notice shall issue for that purpose, returnable on, keep it after 3 weeks.
Your lordship, there is a stay application as well. And if the petition